Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 7 and 8 on the speed of 90 words per minute. Start. The appellant and the respondents are plaintiff and defendant numbers 1, 2 and 3 respectively in the suit presented in the court of subordinate judge Varanasi. The plaintiff in the suit claimed for the reliefs of directing the defendants to execute a fresh sale deed with regard to the suit property in pursuance of an agreement for sale dated 27 to 2006 on or before the date that may be fixed by the court, and failing which execution of the sale deed by the court. She also prayed for grant of permanent injunction restraining the defendants from disturbing with her peaceful possession and enjoyment of the suit property. According to the plaintiff, first and second defendants jointly entered into an oral agreement on 27 to 2006 to sell the suit property for a consideration of rupees 1,83,000. It was agreed that the sale deed in pursuance of the oral agreement for sale would be executed and registered on the same day. The plaintiff purchased the stamp papers and paid the entire sale consideration to the defendants. Thereafter, the defendants put the plaintiff in possession of the suit property and also executed a sale deed in her favor. On 27 to 2006, the said sale deed was taken to the sub-registrar's office. The sub-registrar, however, informed that in view of an order of attachment of the suit property, the sale deed could not be registered. The plaintiff averred that she called upon the defendants to get the sale deed registered, but the defendants avoided the same by putting forth the reason that attachment in respect of the suit property was subsisting. Mr. D.R. Sharma, learned counsel for the respondents, however, strenuously urged that 1911 Act is a complete code by itself and is a special law, and therefore any dispute regarding the registration, including the refusal to register by any party, is covered by the provisions of that Act, and the remedy can be worked out under it only. He referred to sections 71 to 77 of the Act and submitted that refusal to register a document by a party is exhaustively dealt with by the said provisions, and the provisions of the Specific Relief Act 1963 cannot be and should not be invoked in a case of failure to register a document which is complete in other respects except for want of registration. Learned counsel for the respondents submitted that the defendants refused to admit execution of the said document before the concerned sub-registrar because of the fraud played by the appellant, inasmuch as instead of writing an agreement to sell, she got executed a full-fledged sale deed contrary to the agreement and understanding. The defendants accordingly walked out of the office of sub-registrar without admitting the execution of the sale deed, and under these circumstances the only remedy available to the appellant was to get an endorsement and then file an application before the registrar under Section 73 of the 1911 Act. The first respondent resisted the suit, contending that the appellant had purchased the suit property during the pendency of her suit for partition, and that being a purchaser pendent light, the sale in his favor was hit by the doctrine of lispendence, and therefore he could not claim any right in the suit property. She asserted that the suit property was not the self-acquired property of the second respondent, and that the suit property was purchased by her father in the name of the second respondent. She denied that there was any collusion between her and the second respondent. The second respondent did not contest the suit. The trial court, by judgment dated 6/7/2005, dismissed the appellant's suit. It held that the suit property was not the self-acquired property of second respondent, and that there was no collusion between first and second respondents, and that the appellant, having purchased the suit property under sale dated 11/4/1990 during the pendency of the suit for partition filed by the first respondent against the second respondent, the sale in his favor was hit by the doctrine of lispendence, and therefore the appellant did not get any title to the suit property, and he was not entitled to the relief of declaration and injunction sought by him. The appeal filed by the appellant was dismissed by the first appellate court by judgment and decree dated 26/3/2008. The second appeal filed by the appellant was dismissed by the High Court by the impugned judgment dated 1/9/2009 by holding that appellant was a pendent light purchaser, attracting the doctrine of lispendence under Section 52 of Transfer of Property Act 1882, and therefore the courts below were justified in ignoring the purchase by appellant. Feeling aggrieved, the appellant filed the present appeal. The partition suit was decreed, holding that the first respondent was entitled to half share in the properties which were the subject matter of partition suit, including the suit property. In the final decree proceedings, an equitable division was made accepting the report of the commissioner, who had divided the suit property as per the sketch, resulting in approximately 3/4 of the suit property being allotted to the first respondent and only the remaining one-fourth of the suit property being allotted to the second respondent. The contention of the appellant that the partition suit by the first respondent against the second respondent was collusive, and that the suit property was the self-acquired property of the second respondent, and the first respondent did not have a share therein, have been concurrently negatived. The alternative contention of the appellant that even if the first respondent had a half share therein, the division and allotment of the properties in the partition suit ought to have been made in a manner that the entire suit property was allotted to the share of second respondent to work out equities, was also negatived by the courts below.